one.
Thank you.
It's being recorded by Milton Access Television.
Good evening. My name is Jeff Mullen. I'm the acting chair of the hearing for the comprehensive permit of 582 Blue Hill Avenue. Today is October 27th, 2021. With me are Giselle Joffer and Frank O'Brien, members of the Board of Appeals. Tonight is, bear with me, tonight is I believe it's the 30th.
I think it's
29th, 30th session of the board, 30th session of this hearing. I want to welcome everybody tonight. At the last hearing, we, Judy Barrett, our consultant, had published some proposed conditions for this hearing. We had left the hearing open for the purpose of accepting comments on the conditions, and in particular, wanted to hear from Mr. Hill, who's responded and recognizing he represents the neighborhood, and importantly, get feedback from the members of the town officials and our peer reviewers on the conditions, all of which has now happened. So I want to thank people for cooperating with that extended schedule. We now have the testimony on this hearing, and I'm prepared tonight to close the testimony. Before we do that, I think we just take stock of where we are in the hearing, and get a sense of the board of how to move this forward. So tonight's goal is to catch people up. I'd like to hear from Mr. Zawinski as to whether the town, on the nature of the town's comments. I have one issue to discuss with him, and we'll do that tonight. And then I hear from the board members on their sense of the application. And I'd also like to invite our expert consultant, Judy Barrett, to give the board some guidance on the path between the closed hearing and the date by which the decision will need to be rendered, which I believe is 40 days from the close of the public hearing. So we'll put the board on the clock under the statute, and I'm mindful of that. Any questions on that? Does that sound like the right agenda for the hearing? I ask the applicant in particular, and the members.
Good evening, Chairman Mullen. That sounds like the correct outline to me. Thank you very much.
Okay, any comment from the members at this point before I ask Mr. Zawinski to comment?
Mr. Chairman, I'm going to have one or two questions procedure-wise, but I'd like to hold those in abeyance until Mr. Zawinski has had an opportunity to speak.
Great. Okay, thank you. Ms. Joffer.
Good evening, and thank you. I have a question for our expert, Mr. Reardon, before we close the official session. So I'd like to do that at some point.
Okay, so let's hear from the town, and then we'll ask Mr. Reardon the question, and we'll seek guidance from Ms. Barrett, and we'll go from there. How does that sound?
Sounds good. Thank you.
Mr. Zawinski, do you feel comfortable that you've got the comments you need from the town officials to?
Yes, Mr. Sorry to cut you off, sir.
No, you go ahead. Go ahead.
Yes, I think at this stage in the proceedings, a lot of the comments and feedback and input from the town has actually been either addressed or incorporated into the site plan, to the extent that there weren't a lot of conditions that we had real substantive comment on. I submitted, I believe, 3 comments last week prior to the Wednesday deadline, 2 of them from Chase Berkeley, the director of DPW, and 1 from Chief Madden, the chief of the Milton Fire Department. I don't have, I'm on my phone, unfortunately, I don't have those comments at my fingertips, but I did, in addition to sending them to the board, I sent them to the applicant so that they had a chance to take a look at them and provide any edits or any kind of adjustments to the conditions that they had been proposing. So I may shortly ask Mr. Schomer to step in to at the board's pleasure to talk about the adjustments to the conditions. The two things that that Mr. Berkeley had brought up are items that had come up earlier in the hearing as part of his testimony, and that for whatever reason just hadn't made it into the initial draft of the conditions. And these had to do with some of the permits that DPW requires as a as a matter of course for any type of project that is touching town infrastructure or entering the right of way for a construction project. And really, what it is, and you may recall some of this testimony from previous hearings, is that the bylaws that we have on the books in some cases, have over the years become more kind of staff and administrative level approvals rather than kind of permits issued by the Board of Selectmen, for instance. And the regulations just kind of haven't caught up with that common practice. And so I think, part of the issue that we've been kind of wrangling with is, well, we don't want to waive these requirements because they're kind of staff level administrative requirements that have to do with licensure and just ensuring that DPW is kind of in the loop on construction projects. And so it's really just been about crafting a sufficient enough condition that gives DPW the ability to continue to do those necessary staff level approvals that don't require discretion on the part of an elected board, but also waive the requirement in the spirit of the 40B comprehensive permit regulations. And so, again, not having the comments on my fingertips, I may have to take a pause to kind of bring those up. Or if you would allow Mr. Schomer to kind of talk through the proposed conditions that he made in relation to those comments from Mr. Berkeley and Chief Madden, I think that might be a good way to go.
Want to do that now?
That works for me.
Mr. Schomer.
Sure, certainly. I was just trying to see if I could pull those up, but I'm not quite quick enough to pull up the comments that were posted on the town's website. Just to bring you up to speed, Mr. Chair, I was in touch with Tim Zerwinski, I believe it was yesterday, and I have had a chance to review the comments that were posted from Chase Berkeley and from Fire Chief Madden. We don't have any problem with any of those conditions or requests for changes that they made. Specifically, the comments from Chase Berkeley had to do with a couple of points that we've discussed a couple of times, and those have to do with the town's right-of-way bylaw and the town's right-of-way regulations that are on file with DPW and the town's police bylaw. And both of those, as Mr. Zawinski mentioned, they have provisions that contemplate a permitting process through the Board of Selectmen, now known as Select Board. The extent of those waiver requests were simply limited to a request to waive the requirement to go to the Select Board. We're not asking for a waiver from the general permitting process or trying to get around Mr. Berkeley's normal process of overseeing those kind of routine permits that happen for infrastructure work on any kind of project, whether it's a 40B or not. So that was the conversation that I had with Mr. Zawinski yesterday. We have no problem with language being carved out to those to preserve Mr. Berkeley's oversight over those permits and to ensure that his standards and requirements are complied with. The other comment that he had made had to do with the town's inflow and infiltration regulations, and specifically what he was commenting about had to do with his discretion under the town's regulations to require some combination of direct removal of I&I as opposed to monetary contributions or some combination of the two. We have no problem with language being modified in the decision to affirm his discretion to require direct removal or monetary contributions or both, subject to the town's standard policy. In that regard, I think there's been a lot of testimony that a significant portion of the sewer line is being removed for the infrastructure installation. So I think there will be a fair amount of direct I&I removal no matter what. So I think that what he's concerned about will be realized in the final plans. So again, we have no problem with that change. The one change that Fire Chief Madden had was had to do with a reference to the NFPA requirements, and I believe it's NFPA 241, and this had to do with condition F10. I have no problem whatsoever with adding a reference to that NFPA requirement. It's required by law no matter what, so no problem there.
And Mr. Chair, if I can just add just something related to the I&I condition. If we could have Chase Berkeley with us every night, I think it would be great. You know, because I think he's a font of knowledge and a true professional. But unfortunately, you know, he's got other commitments. But we had a conversation at a past hearing about you know, the concept of I&I mitigation, which is, you know, you've got to pay a certain dollar amount for every gallon or whatever. And you know, the problem kind of was broached at one point of, well, you know, that's just money. And if the town wants to do something somewhere else, then it's not actually kind of mitigating, you know, the circumstances that are on the ground in this project. And you know, fortunately, as Chase kind of, you know, swooped in at the 11th hour to remind us, is that our regulations in town kind of allow for an either or situation, as Mr. Schomer just mentioned, that, you know, if there is a direct impact or a direct, you know, instance of infiltration, you know, that we can potentially get rid of, our regulations allow for, you know, a kind of, as it were, an in-kind contribution of, you know, while you're in the ground, kind of fixing that problem. So I think, you know, this condition actually addresses, you know, at least partially, some of the concerns that were raised previously in the hearing, you know, of folks, you know, who had mentioned that, you know, it's good mitigation, but it's also, you know, cash that kind of goes into a pot. You know, what this condition will do is give the town, you know, the ability to you know, do some good work on the site or in the vicinity of the site, you know, while they're in the ground over there. So I think it's a good condition, and you know, we appreciate Chase picking that up.
Great. Okay, any other comments around the town's conditions from the members, or Mr. Zawinski or the applicant?
Nothing for me, Mr. Chair.
Okay, all right. So Ms. Jaffa, do you want to address your question to Mr. Reardon?
Yes, thank you. So my question arises actually from Mr. Berkeley's testimony also. And when he testified with relation to the sewage system, he recommended that there be a third party construction inspector to supervise the construction of a sewage line, which he, I think, you know, suggested was delicate and shouldn't damage existing structure. My question for you, Mr. Reardon, is whether you agree with that, one, and two, whether something similar would be appropriate for construction of the stormwater drainage, which also seems to be complex.
Yeah, I would unequivocally say that oversight is good. The difficult challenge is striking the appropriate balance. So I agree with Mr. Berkeley completely that some oversight is required. Frequently, it's done by the design engineer. A lot of times, the design engineer is not even involved in construction, so you end up having to fix things after they become a problem. So someone needs to be charged with overseeing the construction at some level. For both anything that the municipal system relies on, either direct repairs to the municipal system or things that discharge to it.
When you say somebody, you mean third party somebody?
It doesn't necessarily need to be a third party. It could be the design engineer and have appropriate certifications and attestations from them. Yeah, as long as there's someone other than the contractor that's professionally qualified to oversee the work, yeah, I'm comfortable with that. I think it's generally better to have a third party or someone that does not have a sort of a financial connection to the developer. But typically it's not atypical to have the design engineer oversee a good portion of the work and then issue a certification after the fact.
Ms. Jaffer?
Thank you. That's helpful.
Anything further, Ms. Jaffer?
Not at this time.
Ms. Barrett, can you share with us a bit of a roadmap and provide the board with your expert views on what we should expect and where we should go from here? Just a little bit of advice, please.
Sure, happy to, Mr. Chair. So if the board votes to close the hearing tonight, the hearing is over. There's no more testimony to the board. There's no more evidence submitted to the board. It's done. It now is in your hands to make a decision, approve a written decision, file it with the town clerk so that the 40-day requirement under 40B from the close of the hearing is met. You would make that decision tonight if you felt like you had all the information you needed to make a decision. If you don't need any more information, if it's just a question now of going through all the content that you have and in order to be able to take a vote and to approve a written decision, then if you have all that, then you can close the hearing. And from that point on, you are in meetings that are governed by the open meeting law, but you're not in a hearing anymore. So it becomes the board, probably me, probably Tim, and everybody else becomes an attendee. Everybody else disappears. So they can observe just like they would any other open meeting, but they're not at the table anymore. So the beauty of that, of course, is you're at the point now where you got reams of so much stuff on this project. It's a little bit daunting, but we kind of go through that. I take your comments on the draft that I did. I was telling Jeff earlier that I always appreciate the comments from the boards because I learn from you people every time I work with a new board. So I'm happy to take whatever comments you have. If something's not clearly written, I want to know. If there are comments from the applicant or Attorney Hill that you want to incorporate in your decision, you can tell me that. It becomes my job to keep a running draft going for you to be able to vote on. And of course, right now what you have is just the conditions of approval, whatever those might be, assuming you vote to approve the project with conditions. I still have to add on to it, the other pieces of a decision, but they're not the things that everybody cares about are what are the conditions, what are you actually voting to approve and what are the conditions. So I'd like to get through that first. And I think if you do vote tonight to close the hearing, then we probably should look at a posted meeting on Zoom, in 2 weeks. Let me go through the comments from you, the comments from the applicant's attorney, the comments from Attorney Hill, the comments from Tim, and work through kind of a second draft that I would get to you a week before the meeting so you could look it over and make it better. And we use that as a discussion document, if you will. So it's really an iterative process, Mr. Chair. From once you close the hearing, it's getting to a decision you can vote to say, yes, we're ready to file this with the town clerk, whatever that decision is. And it's just, there's no other way to describe it. It's an iterative drafting process with the board weighing in. Did I hear you? Did I not? Is there something you want to address that's not there? Tim and I have gone through it. We have some additional tweaks we think should be made. Here's a revised draft. That's kind of how it works. So that's what you can do.
Okay, I understand. Let me ask the members if they have any questions of Ms. Barrett.
I have a couple of questions, Mr. Chairman, if you don't mind. I'd like a little bit of clarification about what closing the evidentiary portion of the hearing means. And I have a couple of specific questions. It may seem like a stupid question, but the only stupid questions are the ones that aren't asked. So here goes. If we do vote to close the evidentiary portion of the hearing, does that preclude the board from reopening the evidentiary portion to gather additional evidence if it seems like further information on a particular topic that comes up during the board's deliberations is needed? Or is that not allowed?
You know, usually by the time we get to this point, nobody wants to reopen a hearing anymore. So I actually have never had that happen to me. I think if you wanted to reopen the hearing, you'd have to advertise it. You'd have to do all that all over again, because it becomes then a matter of, you know, you want to ask Attorney Schomer or the applicant or Attorney Hill or somebody some questions, then everybody has a right to hear all of that and everybody has a right to weigh in. So I think that if you're going to close the hearing, you probably should have a comfort level with you have enough information to make a decision. If something that is bothering you is a purely technical question, a clarification of something, I can handle that for you. You don't need to reopen the hearing to do that. If it's a substantive matter, Frank, that might affect your decision, that would be a different matter.
Okay. So you've partially answered my second question. There has been a lot of technical information that has been given to the board, particularly on the civil engineering side of things, especially on the drainage and other issues. Is the board allowed during the course of its deliberations on air, for example, if we had a question, to reach out to and ask a question of Mr. Reardon or seek a clarification of a technical point? Is that allowed? Does that constitute reopening the hearing?
No, if you are asking for a technical clarification from your own consultant, you can do that, or you can ask me to get that information for you and I will bring it to the next meeting. But you don't need to reopen the hearing to get a clarification, a technical question answered by your own consultant.
What if the technical clarification is asked of the applicant's consultant?
I'm not going to recommend that you do that.
Okay. Thank you, Mr. Chairman. Thank you, Judy.
Okay, further questions, comments from the board? Anything further from the applicant?
No, thank you, Mr. Chair. I agree with everything Ms. Barrett said.
Mr. Hill?
I'm good, thank you.
Okay, so here's my sense. First thing I want to say is this hearing started on December 10th. And based on where we are, it will close almost exactly 1 year from the date that it opened. We've had 30 hearings and taken a lot of people's time. I personally have learned a lot. I'm sure that everybody's learned a lot about an important statute, an important issue for both the Commonwealth and the town of Milton. I want to, as the acting chair, I want to first thank my colleagues and members of the board for investing their time and resources in doing this. I also want to thank, so thank you for that. I want to thank, Ms. Barrett, of course, and peer review consultants. I see Mr. Reardon here tonight. Thank you. Mr. Bower and the historic and landscape experts we had, and Mr. Dirk and transportation experts we've had for their expertise. I want to acknowledge the skill and time that the town officials have put into this. I know this is only one of several 40B and applications, and 40B is a small part of what the town officials are doing. So they've got many challenges. I want to acknowledge the work of Ms. Sutton in a pretty challenging environment during the pandemic, learning Zoom and familiarizing herself with the intricacies of the procedure that's required to be followed under the statute. And she's done a terrific job, also recognizing that she's managing several other 40Bs. I certainly want to acknowledge and thank the applicant for the time, Mr. Schomer, for his professionalism, Mr. Tamposi, as well, for hanging in there and modifying the plans at our request, and sometimes not at our request, or perhaps to our frustration, but nevertheless, we're getting there and making progress and learning along the way. And lastly, I want to thank the neighbors, Mr. Hill and his expert representation, and the neighbors who have expressed interest and been really terrific throughout. I met one of the neighbors recently in a semi-social, well, it's a very social setting, but not a professional setting, and had a nice conversation. I'm always reminded that, that we are, after all neighbors, because we live in this town too, and that's a really important part of this. And to people's credit, they really recognize the North Star here of affordable housing, which is such a critical issue, has been articulated by many public officials over a long period of time. And I wish, like a lot of people wish, that Milton was chipping away at its affordable housing stock over the last 40 years. That didn't happen. And so we can't go back in time. What we can do is start to work on this. And I think this, as painful as this hearing may have been for many of you, or many of us, we are nevertheless chipping away at this problem. And for that, I'm grateful. I'm also grateful for the process. I'm personally a believer in process. And I think it's important to hear people out and to show people respect, and I hope we've done that. Now, with that said, I certainly want to, so thank you everybody for all of that, and I'm sorry to go on, but I wanted to say that, and I'm sure there's people that I miss, and should have certainly acknowledged the planning board and the select board for their participation, their diligence and their thoughtfulness in getting us to where we are, and for showing the leadership that they have. So thank you to that. And also thank Mr. Leonard, who's been an abstention, but he's been a helpful resource as we've walked through this. With all that said, my sense is that this is an application that can and should be approved with conditions. I believe that while we could be proven wrong, but we have enough evidence tonight to articulate those conditions in a thoughtful way that properly balances the requirements of the statute and the needs of the region with the local concerns that have been expressed by the town officials, the testimony that we've taken from the neighbors, and the other information that the board has assembled. So that's my sense. And I would like to recommend that we move to close the hearing tonight, which would put us on a path to issue a written decision between now and December 6th, I believe. I believe that's 40 days from today. Could be wrong, but I think that's right. I consulted my red book. Those of you who been practicing law for a while know what I'm talking about. Others, perhaps not. Mr. Hill knows what I'm talking about.
December 6th.
December 6th, yeah. I'd like to, what's the pleasure of the members? With that said, what's the pleasure of the members? Ms. Joffer.
So I would like to start by thanking you, Mr. Chair, for your professionalism and leadership and maintaining your patience 99% of the time during these 30 hearings. So that was much appreciated. And would also like to echo your thanks for the many neighbors, our neighbors, as you so well put, in Milton, who came on week after week and really gave us a perspective that we otherwise would not have had. And I do want each and every one of you to know that we have heard you, and we've taken your thoughts into consideration, and we'll continue to do that in the deliberations. For me, looking back at the hearings, we've covered so many different topics and looked at this project from many different angles, right? From the angle of the neighbor, but also from the angle of the resident, and from the perspective of the town as a whole, and the town during the course of construction, but also the town 10 or 20 years down the road. And in that way, I think that it has been a comprehensive review and assisted by, a ton of experts on all sides who've also added greatly to the project. I think that Ms. Barrett should get a lot of credit for the fulsome and detailed conditions. When I look at the conditions, I think there are a few that we can add and discuss further in the deliberations. And, many things came up, and I'm sure we'll each have a voice in that. So I still don't know that we're quite there with the way things look now, but I do agree that after this #iterative process, we have landed in a place that, there's a potential project here that could be approved with further discussion. So I don't know if you have a motion on the table, Jeff, or not, but I feel that I have sufficient information to close the hearing and move on.
Yeah, no, I didn't put one on the table. We're gonna get a sense of the board, but we'll get back to that, and
Okay.
I'll lay one on the table, and we'll consider it. Thank you, Ms. Joffer.
Yeah.
Appreciate that. But
with one thought that it may be appropriate to get final comment from any neighbors before we finally conclude. Thank you.
okay, Mr. O'Brien.
Thank you, Mr. Chairman. And not to belabor the point, but I too join my fellow board members in thanking all of the participants who took the time and energy and whose patience may have been tested by me, certainly by not the other board members, in terms of educating me and educating the rest of us relative to their specialities. Also very much appreciate the input of our neighbors, as you so well put it. I appreciate the opportunity to learn more than I ever thought I would learn about drainage, traffic studies, photometric things. Lord knows, over the course of 40 hearings in almost a year, there have been a lot of things that we have had to wrestle with. Mr. Chairman, I too find myself in the position of coming to the conclusion that there is a project here that can be approved with conditions. It has been a long time coming. Is this the perfect project? No, but no perfect project exists. Is it a project that could potentially be a very good project? Yes, I think it could. Are there downsides? Yes, I think there are downsides, but being mindful of the obligations that we as a board have under 40B and our statutory responsibilities, I find myself coming down in that particular point. So at the appropriate time, Mr. Chairman, I would be prepared to vote in favor of moving to close the hearing. I do think, however, that Ms. Joffer does make an excellent point in that if there are additional comments to be made by the general public, I think that would be an advisable thing to do. So thank you, Mr. Chairman.
Okay. Mr. Schomer, do you have anything you want to say before I take questions, comments?
Nothing further substantive for me, Mr. Chair. Thank you to you and to the members and to all who have participated. I think that the project has come a long way in the last 11 months, and I think we're in a good place, and we appreciate everyone's part in that process. So we look forward to attending and listening to your deliberations and seeing what the decision comes out as.
You're welcome.
Thank you.
Mr. Zawinski, do you have anything you want to add?
No, sir. I think everyone has said it all. So thank you.
Mr. Hill?
I really have nothing substantive to say. I do want to echo the comments that have been made. I've been doing 40B hearings for 15 to 20 years now, and I can honestly say this has been one of the most well-run hearings that I participated in, and I think you all deserve a lot of credit for that. It's been very professional from top to bottom. We appreciate all the time you've given us as neighbors to provide input through me, through our experts, and lastly, through the comments we made on Judy's decision. And we hope that's been helpful to you, and we urge the board to adopt some of the language that we proposed.
It certainly has been, and thank you for that. Okay, let me ask if there's anybody in the public who'd like to be heard at this time.
There are no hands up right now. Still none. Rob Lavash.
Mr. Lavash?
Good evening. Yes, as a neighbor, and I will echo what this board as well as our attorney has said. I hope that this board will, understand some of the comments that we have given. Obviously, it's been a long process that we've gone through. I echo what Jeff Mullen and as well as Frank and Giselle have said about some of our concerns, but also the need for affordable housing in Milton. I think we can all be on the same page that I do think that this project should be approved. However, I do think there does need to be some recognition of some of the comments that our attorney has made and some of the neighbors' comments that have made. But overall, that's the whole reason for this iterative process and the 30 hearings that we've gone through. And I just want to say that everybody's handled this very professionally, and I'm very glad for that. So thank you.
Thank you, Mr. Lavash. Anybody else?
There are not. There's no one. No.
Okay. Okay. All right. So let me put a motion on the table that the board that we vote to close the evidentiary portion of the hearing for the purposes of entering into deliberations on the conditions pursuant to which the application will be considered and potentially approved. Do I have a second?
Second.
Favor?
Aye.
Aye.
Opposed? Okay, so we'll consider the evidentiary portion of this hearing closed, and I'd like to, Ms. Barrett has recommended that we convene in 2 weeks' time. During the intervening time, we provide her with comments. She'll have had an opportunity to consider the comments that have been assembled, to refine her conditions, and we'll enter into a more robust or a robust conversation about the proposed conditions. I wonder if any of the members have a comment on the conditions at all now, or if you just like to hold your comments until that time. Either way,
I prefer to hold my comments until that point in time. However, after spending a professional lifetime working with various iterations of documents, it's always important, at least it's my experience, it's always important that we make sure that we are all talking about and working from the same document.
Mm.
So if Ms. Barrett, through you, Mr. Chairman, if Ms. Barrett could note for us now which document specifically we should be working off of so that we're all in the same place?
So my draft is the one with all of its imperfections that, that the proponent and Attorney Hill have commented on. I'm going to edit my version, I'm not working from theirs. So what I would typically do for a situation like this is when I give you a revised draft, it's going to be a revision of my document where I've accepted something they said, I will highlight it. Where they've made a comment that I did not accept for whatever reason, I will footnote it. If I change something that's my own wording based on comments from Tim or the DPW director or you folks, I'm going to redline that. So, and I'll have a key in the footer so you'll know what's what. But I will work from my draft. Mine already has a series of style formats in it for the numbering and so forth. So I need to preserve that because if I start moving text around, I need the renumbering to happen automatically.
The draft that we have was provided to us on October 12th. It's dated October 11th.
If you would like me to send that again, I
52
will.
pages.
If you want me to send it again, I will. I'm happy to. That would make it easier for the board.
Mr. Chairman, that would make it easier for me. I've always found it when you're working with a lengthy document like this with multiple revisions that we proceed from this step forward knowing exactly what our base is.
Okay.
Each time I give you a revision, Frank, I'm going to date it. I'm going to put a version number on it.
Thank you.
You're welcome.
Mr. Chair, I do have some big picture reactions to the conditions. Through you to Ms. Barrett, what is sort of the most convenient way for you to receive those? Should I talk about those now? Should I submit those in writing?
You can talk about them now if you feel that there's a need to discuss them, or you can simply email them to me if you want.
Okay,
Is that all right?
Let me just touch on them quickly.
Sure.
And before I do that, on Mr. O'Brien's procedural point, if it's not too difficult for me, having a table of contents or outline for the conditions would be helpful, just so I can track the different headings as a guide.
Okay. That's not necessarily going in the final decision, but something you can have as you're going through reviews of different drafts. I'm happy to do that.
Great, thank you.
I've done that before, so that'll be an interesting effort for me, but yes, I'm happy to do it.
Okay, thank you.
I keep you organized too.
So my first comment relates to the question I posed during the final hearing session relating to having a third-party construction inspector for sewage and water.
Mm-hmm.
And I don't know if that's in there or not. Honestly, it's such a long document. I don't think I saw it. And that goes for frankly all of my comments. But that if not already in there, that's something I think I'd like to add, at least for discussion with my fellow board members. Relating to water and sewerage, I understand that the lack of a formal recorded easement is not within the board's purview as far as site security. What I don't understand is what happens if that's not resolved, which then renders the current plans for, I believe it's sewage, unworkable. And whether that's a contingency we should account for in the conditions. So that's a question. Moving on to another topic focused on the historical garden.
Mm-hmm.
Mr. O'Donnell had suggested that we have a condition for an endowment to allow for the continued preservation So I would rely on your expertise there with respect to whether that's appropriate and what amount and how that's phrased.
So if you don't mind, what I'll do is I'll check with the historic preservation consultant and run that question by her.
Next, with respect to health, I think the Board of Health commented on, with respect to residents on a going forward basis, no smoking or vaping inside the building with a buffer zone of 25 feet away from the building. And then also related to health, let me know if I'm going too fast.
No, it's all right.
Is it okay? But also related to health, a plan for the garbage, which I actually think was laid out in a satisfactory manner, but maybe not in writing at any point, to my knowledge.
I think the decision simply needs to say that they have to have a trash management plan or trash removal plan approved by the Board of Health.
Perfect. And then on safety, I had a note that the fire chief said that only two stairwells were going down to the garage, and all stairwells should have access to the garage level. And I don't know that we need to be that specific, and maybe that's covered by the fact that the fire chief still has to approve a plan.
Mm-hmm.
But I did note that, along with much discussed whether emergency vehicles can turn around the roundabout and those curves.
Mm-hmm. I believe there's been discussion with the applicant's engineer or with Sean about that. Sean, I may ask you to step in on this. Is this ringing a bell? Or Tim? I think you guys had maybe at least one discussion with the fire chief or DPW or someone that I wasn't part of. So
Yeah, we didn't have a conversation specifically with the chief, but we did discuss this at the hearing. From my viewpoint, the circulation around the site for emergency vehicles is satisfactory. I don't know if
Yeah,
there are
I think,
concerns.
sorry, Sean. The last kind of big issue around that I recall was the sort of pinch point in the lower, it's not the right direction, but the lower right-hand corner of the kind of circumferential drive, which I think was, there was an adjustment made to the plan to allow for that movement. I think that all of these were kind of addressed in the plans. But I think, if we want to talk about a condition, for, a final review, prior to construction, I don't know if that's appropriate, but, those may not be written conditions in the decision. Those may have already manifested themselves in the plan.
Right. Yeah, I was unsure because I had a note from a September hearing where I believe the applicant sort of said, look, we think it's fine, but if not, we're happy to have a condition saying that if for any reason it isn't, we'll make it work. I just want to make sure it's not lost. So,
but thank you for bringing it up.
Yeah, however you think is best, I'm willing to consider that. And then finally, just in terms of big things that rang out to me on non-discrimination and equal access, I was happy to see the non-discrimination condition there. I don't know, and also there's sort of the number of affordable units or the percentage at 25%. I don't think we stipulate the number of accessible units, and I mean ADA accessibility, and I don't know if that's within our purview or is otherwise regulated. State code, okay. I just wanted to make sure that wasn't something that we were waiving or should address.
No, I mean, I think I've seen boards negotiate with an applicant to increase the number of accessible units, but that's sort of done before the hearing, before the decision's actually getting cast in concrete. Otherwise, it's not, you don't know if the applicant would accept that. And so I'm not going to recommend that you do that now, but I think that is a function of state code. They have to meet state code.
And that would be the same for sort of any ramps or any other type of accessibility.
Yes.
Yeah. And is there typically, I know there's state code, but isn't there also typically some type of local approval with respect to ADA accessibility. And I'm saying this just based on, frankly, personal experience with the town on this.
Not that I'm aware of. I mean, the building inspector would determine that, in fact, the plans, the final construction plans comply with
Right.
this code, but I'm not aware of any local requirement. Certainly not a requirement that wouldn't be in excess of the state code requirement.
Right. Sorry, I didn't mean a local requirement. I just meant a local level approval.
It'll be a local level of approval to verify that the project complies with state code.
Okay, good. And we're not waiving that right here.
You can't waive state code anyway. The only thing you can
Yeah.
waive is the regulations of the town.
Okay. So you don't see any reason to put any language related to that into the conditions?
Well, I don't think so, because they have to meet the state code requirements. That's not waivable by the board. Like, just like you can't put conditions in your permit that affect the State Wetlands Act. The state code is the state code, so they have to meet that. Well, I think one of the things I try to avoid in these decisions is starting to recite a bunch of stuff that somebody else already makes sure they have to do.
Right.
Because at some point, these things just become, I mean, I want to get it down from 52 pages. Frankly, a lot of this is because of the number of footnotes in there. But I think if it's going to be handled by another jurisdiction, building department or whoever, let them deal with it. They have to do it anyway.
Yeah, that makes sense. Though I think that probably the same could be said for the non-discrimination.
Mhm.
But right, I don't know. This is very helpful to know that it's included. And those were just the few things that struck me immediately, and I'm sure I'll have more.
Giselle, if I could just ask you to clarify, when you talk about non-discrimination, are you talking about access to the affordable units being non-discriminatory?
Yes.
Okay.
Yes.
So let me explain to you how that works. I just think everybody ought to know.
Sure.
Before they have to, as part of going through what's called the final approval process, they have to prepare, among other things, what's called an affirmative fair housing marketing plan. The subsidizing agency approves that. The board actually does not have jurisdiction over affirmative fair housing marketing, but the applicant has to do it. So they have to provide a plan to, in this case, Mass Housing, that lays out how they're going to do outreach to people of color, to people with disabilities, to people who may be vulnerable to age discrimination, to family size discrimination. They have to account for all of that in that plan.
Okay.
Typically, they would give it to, say, the planning department a couple of weeks before they file it with Mass Housing to make sure somebody at the local level is looking at this document and making sure there isn't something in it that's a problem for the town. But they would do that, and then it would get filed with Mass Housing. But pretty much it's all regulated by the subsidizing agency.
Okay. Thank you. Very helpful.
Okay.
Nothing further from me. Thank you, Mr. Chair, at this time.
You're welcome. Anything further, Mr. O'Brien?
Nothing further, Mr. Chairman.
Okay, so the question on the table is a reschedule to schedule the initial discussion. I'm aware that Ms. Sutton won't be available 2 weeks from tonight, and therefore I'm wondering if we should schedule this for 3 weeks from tonight. We are going to have an issue with accommodating the Thanksgiving break, so we're going to be right up against December 6th. So I'm saying that for Mr. Schomer's benefit, so that he won't be surprised when we're up against December 6th. But we've sat through 30 hearings with Mr. Schomer, so I'm not going to ask for an extension of December 6th tonight. But I don't think we can do any better and still have access to the Zoom system and Ms. Sutton's talents any sooner than 3 weeks from tonight.
That's the 18th of November. Yes, Mr. Chair.
17th.
Oh, I'm sorry. I'm looking at Thursday nights. I have meetings every night. I have so many 40Bs right
No,
now.
it's-
It's your name.
No, that's fine. Is the 17th okay? If not, honestly, if this is gonna throw any sort of interruption into anything, I am packing, and I'm saying this out loud, I'm packing my laptop. So if we are in crunch, I'll make myself available.
I cannot do the 17th. I have a big community planning forum in another town. I will be tied up that night, asking people to vision their community, which is fun. So that's a night I can't do. Do you have to do Wednesday night at this point? I mean, it's not a hearing anymore. You can pretty much schedule it at your convenience. Yes, Bev, am I wrong about that?
No, you're right. We just have other, we still have the East Milton and we have the other three. We could, oh my gosh.
November's so bad. Oh my God. So I actually do not have a night open right now, the week of the 15th. They are all booked. This is the problem with this time of year.
All right. I will work. I will be available the week of the 10th, the 11th. I'll do it.
Are you sure about that?
No, but I'm going to agree to it. Of all things, I'm certainly not going to be the one to throw a wrench into this. So,
We can, maybe we can affect some type of workaround. We'll talk offline, all right? So
we can just schedule it.
why don't we schedule in the next meeting of the board for the purpose of deliberating on this matter is going to be
November
7
10th.
o'clock on November 10th.
Yeah.
Okay, the board is requested to get comments it would like as soon as possible to Ms. Barrett, and Ms. Barrett will turn a document back to us for review at her earliest convenience in light of that schedule.
I would just offer to the board too, Mr. Chair, if it's easier for you to just talk to me, I could schedule a call and just talk to you, and I could make, red line notes while we're talking, and then you don't have to sit down and write out an email. You would rather do
Board's
that.
pleasure. They have phones. At the board's pleasure.
Okay, that's fine. Just offer.
That's a great invitation. We got a lot of lawyers in this Zoom.
I know.
A lot of people who draft for a living, so.
I know, I'm prepared. I'm prepared for the criticism. I'm fine.
It's not criticism. I think you've done a terrific job. And on behalf of the board, I want to thank you again. So thank you. Okay, so this hearing will be in recess. The meeting will be in recess. The hearing is closed. The next meeting of the board will be on November 10th, and we'll look forward to seeing you then.
Thank you.
Thank
Thank you very much. Bye now. Good night now.
Hey, everybody.
Thank you, Giselle. Good night, everyone.